the main questions on the slide. I've extracted the main questions on the slide. So as you can see, the situation is trying to be fairly realistic about a set of companies that seeks to expand and tries to get you to apply some of the things you've learned over the last few days to the actual fact scenario. So the fact situation involves a number of different corrupt dealings or questionable dealings, not even corrupt, and it's just asking you to apply the law. So the first is to do with the shareholders of Metro Limited and now taking action to begin a class, so it's taking advice to begin a class action against the company directors for breach of duty. So here, what we're looking at is the company, Metro, as well as its subsidiaries, which is Metro Robotics and Metronomics Developments. So I suppose I should ask you, has anyone looked at this? Yes? So how would we go about it? Who wants to start? I had asked you to take on the role of shareholders and lawyers. You were the shareholder. I think all the lawyers aren't going to come. They have gone off. So perhaps we can just discuss what are the main, did you have a look at the potential liabilities? So do you want to start us off and take us through? Yes, come here. Come closer. Sorry, what was the question?
I'll just go through the events in question and maybe point out some of the problems that I found.
Okay.
So, firstly, the first question says that the directors signed off certain audited reports which weren't accurate, and there were hidden liabilities to the amount of 100 million in short-term liabilities which you're supposed to show in your cash flow statement. And I think that I think the shareholders would clearly find this to be a breach of reasonable care and due diligence, on which is a duty of the directors, as we discussed earlier. And they would definitely want to file a suit for mismanagement or ask them to show cause as to how they wish to proceed further now that they've unwittingly incurred such a liability.
Okay, so what we're doing here is we're going through the way in which problems are solved. So the usual way problems are solved is it's a very general question. Advise is the question, the shareholders. So what's happening here is the first thing is the issue is being identified. And the issue, the factual issue and a legal issue. So the factual issue that's being identified is the events under events number 1, which is the disclosure of 100 million of short-term liabilities. So we're advising on issue number 1, which is non-disclosure of 100 million of short-term liabilities. So the people we're advising is the shareholders. Now we're going to the law. What is the legal issues that we're investigating? We've got the factual issue. So what's the legal issues?
The legal issue is that they breached a very important duty that they owe to the shareholders to act in the interests of the company, and to the reason they're appointed to the role of directors is so that they can look after the affairs of the company and exercise skill and diligence in verifying the accounts, and this is what they haven't done. Additionally, there's also a liability on the auditors themselves because they seem to have given us inaccurate results. But I think as shareholders, our primary concern would be that the directors breached their duty, so that we can sue them for mismanagement and probably replace them with someone more competent.
All right. So that first point that's been raised is lawyers should advise shareholders here. So yes. All right.
These companies, I mean, the shareholders of the company, the lawyers are brought in to advise on the merger between MTN and MR. So that would be their main that.
Okay. So in this case, what would you advise shareholders then?
More like their lawyers, like not the freedom.
No, not the freedom lawyers, just lawyers. Any lawyers. They've just gone to their friend who's a lawyer and asked them advice. So not freedom lawyers. So what are you doing?
I am
The executive director.
I could do that.
Okay, you reply.
So as per the statute of the Companies Act, under section 1.3, it's the role of the auditor to prepare the report and an audit report, and the report is to the members of the company of the accounts that are examined by them. And the report has to be as per the accounting and auditing standards that are laid out by the law, and it has to be essentially presented to the members. Now, it's the duty of auditors to prepare the report in consonance with the standards, and they have access to all the financial data of the company. The directors aren't accounting experts here, so there is no
the onus is not on the directors to prepare the auditing.
And it's not the onus is not on the directors to either approve the reports as something that they endorse or something that they don't endorse. The reports have to be made directly to the shareholders, the members of the company. So in light of the fact that the directors are neither experts on accounting standards or on auditing standards,
Or required under the law
to approve or endorse the report of the auditor, I don't think the liability should fall on the directors themselves. Now, what we agree right now is that with the shareholders in stating that the accounts weren't prepared in consonance with the standards that were laid out and how they should actually be prepared. So, in light of that, we would be, I mean, absolutely willing to take action with auditors for not preparing the accounts and audit reports in consonance with the standards required.
So the interesting point that's been made is the duty of directors. Shareholders want a remedy and they want to bring the action against the directors. But the directors are arguing that this duty has actually been delegated to the auditors. So they're saying under 141 of the Act, 143 of the Act, the auditors owe the duty, and the director's duties under 166 is only to exercise reasonable skill and care, and it's as a director rather than an auditor. So even a step before that, you've got to ask the question, the fact that they haven't complied with the standards, is that going to be a breach of the Act? And here you have to ask the question, the National Financial Group, whatever it is, that group, section, I think it's 147 or something of your Act. There is some sort of task force the National Financial Reporting Authority under the audit provisions. This is in section 132. So that body determines certain financial standards. And presumably it is picking up the standards, international standards, and putting them into the Indian standards. Or maybe it's saying that any standard that's been adopted internationally should automatically apply in India. So what you would first be doing is, according to section 132, you're assuming that this National Financial Authority has actually adopted these standards and made them apply within the Act. So the first duty is the national standards are law. Soft law has been made into hard law. The second thing then is whose liability is it? Clearly it's the auditor's liability, and 143 is correct. But you're going a step further and asking whether 166 applies. And you're arguing it doesn't apply because it isn't within their realm. And you could even maybe argue it's been delegated to the auditors. If you remember, I talked about that Centro case, ASIC versus Healy, which was a really new interpretation of very similar provisions under the Australian Act. It's been severely criticised, and it's a really kind of adventurous court that decided it. It said the board of directors should also have knowledge of these standards if they're going to approve it. Otherwise, they shouldn't be on the audit committee. So I don't think that interpretation will likely succeed in India, but it's something to bear in mind, that a person who goes on the audit committee is highly likely to have this expertise. If they don't, they pass the auditor's report, just rubber stamp it, it's going to be a tricky one. Next. All right, there are two things that you're looking at here. The first thing you're looking at is whose liability is it, and then the heading is what heading, what head is the liability under. It's the shareholders you're advising. They most really don't really care whether or not the auditor gets a fine or not. What they want is cash in their pocket. So what you'd be advising is a breach of this act may result in a 25 lakh fine, but that's got nothing to do with compensation for the shareholders. So you might say it's a civil penalty under that section 147. But what we're talking about is civil compensation. So then you're distinguishing between compensation and a penalty. So then you're coming back and asking, what about these shareholders? How can they get relief? Because, sure, part of it is deterring that auditor from going ahead and doing any further work, but part of it is actually being compensated.
Auditor shall be liable to refund the remuneration received by him to the company, and also pay for damages to the company, statutory bodies or authorities, or any other person for loss arising out of incorrect or misleading statements of particulars made in the audit report.
All right.
So that might be owed by the shareholders to say, okay, we will make some further loss, and the auditor, or
to the shareholders,
or to the company essentially, to make good for the damages.
Okay. So the point made there is it is possible to get compensation under 147, but you've got to go a step back and say who can bring that action. So that's going to be your advice to the shareholders. Who is the proper party to bring action against the auditors? No. Do you want to answer that question? So the idea here is about the separate legal entity. And the notion here is shareholders can't really bring an action against the auditors. The auditors they owe a duty under negligence, but still they don't owe a duty to the shareholders. They might, under tort law, if they think that that particular shareholder is relying on the auditor in a special way because of a special relationship. But otherwise, they don't just owe a duty to all shareholders. So the duty is owed to the company and only the company. Therefore, what the shareholders have to do to bring an action is actually pass a resolution in a general meeting saying that the company should mount an action against the auditors. So that is the majority shareholders' power. So that would be your advice. So firstly, there might be a breach. Yes, it could be auditors that have breached the duty, but the company's got to take action. The majority shareholders have to pass a resolution under chapter, I think it's 9, which discusses resolutions under the Act. And it discusses meetings. So the majority shareholders. All right. Any other points? So what we're kind of finding out here is the duty to the company is owed by the auditors, and there's a contractual duty. But the company has got to bring an action against the auditors. To do that, someone's got to pass a resolution. Either the directors can do it themselves, or the shareholders can ask the company to pass a resolution. And if they have the majority, over 50%, that ordinary resolution can direct the directors to take action. Anything else? I think that about covers that first question. The second one is the directors are seeking advice on who they can join in any future action. So you were, sorry, were you going through other points in question 1? Yes, let's go back. Yes, back to you.
Shareholders would believe that there's this transaction between Kushi because the bank that normally finances their transactions is refusing to give any further loans, and the only bank which is willing to finance the company seems to be doing so only because of some connection that with the key person in that bank, the director in that bank. So firstly, the shareholders would like, and also there is a payment of a special fee of 5 crores to this person who is a director. And firstly, the shareholders would like to know what this special fee constitutes and what else are we paying this compensation or consideration to the amount or salary. Next, we also like to point out that this seems to be a related party transaction, and we might want the director who's we want the director who has a relative in that bank to probably step down to and we would also want to provide an explanation on the current financial situation of the bank and whether it's actually feasible to get more loans if our other banks with whom we have an ongoing, with whom we have a past relationship, but they that we're not safe enough to refinance. Like we actually, if we're in any sort of financial trouble, we have to repay our loans, and if we have the mechanism to repay so that we're taking on, or is it just that we're getting to work with the constitution and we need to have
Okay. All right, so the second issue, so firstly, that question asks about shareholders of Metro, not necessarily shareholders of Metronomics. So what you'd have to ask is whether the shareholders of Metro actually have any ability to bring an action for the way in which Metronomics works. And the interesting thing here is Metronomics is a wholly owned subsidiary of Metro. So it's highly likely the shareholders of Metronomics, which is Metro, is going to do nothing. It might be a related party transaction, clearly, but what is the actual requirement for a related party transaction? It's simply disclosure, and that disclosure by Metronomics has got to be to Metro. And that disclosure to Metro is going to be easily passed because it's one shareholder. So what this chain is doing is it's keeping the shareholders of Metro out of any actions between Metronomics and Metro. Does that kind of ring a bell to you guys? Does that... I beg your pardon? Okay. So I'm just going back to the question here, and the point that was being made, which is a correct point, is that this loan that they're seeking in issue number 2, fact number 2, from West End Bank of 100 million, they're getting this because of the related party. It's clear that's a related party under Section 79.
Okay, so as directors,
Hang on. So the point that's being made, the point that we're discussing before is, who is the shareholder of Metronomics? Who is it?
the shareholder of MNDL is it's a wholly owned subsidiary of.
Yeah. So the point is the wholly owned subsidiary that owns all the shares in Metronomics going to make any trouble? And even if it's a related party, what kind of... The related party is going to be of Metronomics. That's a related party. So you can argue that this person is taking a loan or getting some sort of benefit from somebody that's a relative of theirs. However, the only people, even if it's a related party, that they have to make disclosure to is to Metro. So Metronomics only have to make disclosure to Metro. Does that make sense? Are we all on the same page? So I was just saying that it's a kind of a tight situation where the shareholders aren't really going to be able to argue anything, the shareholders of Metro. They could argue their directors have been breaching their duty by not acting in a proper manner, but I don't know what leg they have to stand on, because the directors are the same of Metro and Metronomics, but the actual breach of duty is when they're directors of Metronomics, not Metro. So the shareholders of Metro aren't going to be able to regulate them for what they do somewhere else.
So, not as directors, but as a general point of view, you were talking about how in Australia the shareholders are trying to use derivative action
Trying to use?
derivative action
Oh, yeah.
to initiate legal proceedings against a different company rather than the company's own director, which is usually the point of the reason why it was initially instituted. So that would be an interesting concept to look at here, where there are 70% public, 70% individual investors, and then there's 19% of shares who are held by banks, and then 11% of shares are held by the pension fund. All of them might be interested in saying, okay, the directors of our wholly owned subsidiary are engaging in wrongful conduct, so maybe we should initiate derivative action and proceed against that company.
So which section is the derivative action provision in your Act? Yep, so under 245, who can bring an action? And on what basis? Yeah, I'm pretty sure it's 245. Okay, so section 245 says a member or any class of them can bring such an action. So a member or any class of them, member, depositor or any class of them, under subsection 1, 245, And under section 245, subsection 2, they can seek compensation. But also there's a special power for government. So anyway, let's forget about that. So the thing here is the persons who can bring an action are members or classes of members under section 245 for derivative action. So back to you.
I was looking at the grounds on which and the remedies that you can ask for. And the grounds are actually, like, is a little broad, say that the take action or compensation or any other action against the company or its directors, but again, you're in the sense that the other company is a separate legal entity, you're asking for action against the directors of a different company.
Yeah, you're quite right. The way in which 245 is written is very broad. The orders are broad. The grounds for breaching are broad. But the people who can bring an action is narrow. So the only way you might be able to bring an action is if the shareholders of Metro. Do you want to take us through? Does that make sense to everyone? So there could be agitation. The company could agitate the shareholders of Metro India to pass a resolution directing the directors to bring an action as the only shareholder or member of Metronomics under section 245, and then you can get through. Highly unlikely.
So going back to the concept of these guys would technically qualify related parties anyway, because related parties have been defined very narrowly. So under the Act, it says related parties include means a director or his relative, a key managerial personnel or his relative, a firm in which the director, manager, or the relative is a partner, a private company, a bunch of these.
Hang on, keep going down. So section 79. Yeah, section 79, right? Section 2, subsection 70, what? 77. All right. So I get down there. Okay, so husband and wife. Oh, that doesn't sound right.
So the good second, 77 clause 3 that says any one person is related to the other person in such manner as may be prescribed. Now the rules describe any other relationships that would fall under related parties, relatives, and they include father, mother, son, son's wife, daughter, daughter's husband, brother, and sister.
Okay. So you have to go to section 76, which describes a related party with reference to a company. Is that the one you're looking at?
Yeah.
Oh, okay.
And then 77 defines what a relative is.
Okay, yep. So 76. Okay, that's true. So related party, a director of the company. So in this case, what you're saying is that even though Metronomics is a public company and related party provisions apply to it, the person who they are borrowing the money from doesn't come within a related party as defined by that Hindu Act, because it's a friend, not really, and a second cousin, not really related as in husband, wife, and so forth. So you're looking at the related party and saying they're not a related party. So 2 or 3 things that come up when you answer this question. The first is unlikely for member to bring action. The second is, even if you want to show breach by directors, it's unlikely to show that it's a related party breach. You might be able to show many other breaches under 166, but you can't bring the action to show those breaches. But it's just wiping out the related party breach. All right?
Are the figures correct here? This 100 million, which is 10 crores. So for 10 crore to pay loan, 5 crores were paid to the second person. Are the figures correct?
Well, I'm not very good with crores.
So,
I just made that up.
so this figure, this is 10 crores.
Oh, is it?
Yeah, yeah.
Oh my God, I didn't realize 100 million was 10 crores. Oh, I thought, oh, so crore is more than a million.
Yes, it's 10 million.
Oh, right, no. Sorry, that was a small mistake by me. I just thought a crore was more like 500,000. So that's 5 lakhs.
Yeah.
Okay.
Okay, so this is supposed to be 5 lakhs.
Yeah, sorry, I just wrote that and I didn't really know what a crore was. I just liked the look of CR.
Okay. So 1 lakh is 500,000.
Yeah, cool. Yeah, thank you. All right. It's actually handy because everybody seems to be a millionaire, so it's better to call them a crore-aire. Because... What?
So it's not so a millionaire. I mean, for crore, you use the term crorepati.
Oh, do you?
Like, like,
Oh, cool. Very nice. All right. So can we leave that? And we'll come back to the breaches any minute. Can we go to who they can join? We've already done that, I think, saying that they're joining the auditors. And you've already said that the auditors are going to be joined under Section 147. And you've said that they will be liable for compensation under subsection 3. And you've also stated that this is if the directors join them. Otherwise, the company itself can bring an action against them for breach of that particular provision. All right. The next question is looking at the institutional shareholder. Investiture is disappointed in the director's failure to disclose the guarantees they provided. This is by the 2. MNDL to Metro, and want to know how to proceed. So now we're getting into a little bit more of looking back at that guarantee, not in part 2, but part 3, and seeing whether something else is happening here which can actually give rise to action. The reason for this is it's under point 3. The directors are considering a merger between Metronomics, and Metro Robotics America Limited, and they're being advised by Freedom International. The directors failed to disclose the short-term liabilities of Metro India, which is 150 million. And they leave it to the next AGM. So now we're asking about what the institutional shareholder can do, and the institutional shareholder holds 19% of shares. So how would we go about this? Who's doing? Anyone? Oh, the Freedom guys didn't come. So any? Yes? Anyone at all? All right. What about 245 you were talking about before? What about 245 to start with? Do you want to have a look at whether they would comply with the requirements under 245? You've got the Act. Do you want to take us through? Or whoever. What's wrong? Oh, yeah. So you want to be hammered. We want to think of defences. Oh, all right. Cool. So let us take charge of the action we want to bring against you. So we're looking at class action under section 245, and we're saying that any member can bring an action. So investiture or investitude is a member because they hold 19% of shares. So they can bring an action. And it states that the grounds on which we can bring an action are in what the tribunal can take into account is number 4, subsection 4 of section 245, whether they'll take into account whether the member investiture is acting in good faith and whether there is evidence of involvement of any persons other than the directors and whether the members should bring the action in their own name. So it looks like as long as you can show investiture is acting in good faith, they can bring an action. So they are clearly suffering some loss, so they'll be bringing an action. Right. Right, so the grounds of bringing the action is that there has been management of the company's affairs has been conducted in a manner that's prejudicial to the interests of the company or its members. Under section 245, what they have to show, firstly, a member can bring an action as long as they're acting in good faith. Investiture can argue they are. The second thing they have to show is that the management of the company is being conducted in a manner that's prejudicial to the interests of the shareholders.
Also argue that investiture is in fact not acting in good faith because if the merger goes ahead, they are a minority shareholder, right? And their shares will be diluted even more because of the merger, which is why they don't want their shares to get diluted, which is why they're creating this role.
Okay, you can put that argument forth. So what would be the response to that argument? That investiture, very shaky argument, because there's always more than one purpose for any action, and the substantial purpose is what's going to be considered. And so as long as they're able to show the substantial purpose is actually safeguarding and making sure the management of the company is going ahead, they won't win. But it's a good point to raise. So once we can go ahead with 245, we've got to argue that it's being conducted in a manner prejudicial. And what sort of evidence do we bring in to show that? Okay. Anything else? So under issue 3, the points are being made that you can argue that the affairs are clearly not being conducted the affairs are being conducted in a manner that's prejudicial to the interests of the company. So you're saying the accounts aren't being filled properly. That's completely a breach of duty. because you're supposed to be reporting to members at an annual meeting, and you're supposed to be following the standards. And putting things away to the next year is not really following the standards. And you can go back and refer to 147 again. So they're not following the accounting standards. So that's prejudicial. They're trying to mislead them. Then you can go ahead and say the intention for this is actually to give a separate or different picture in order to make the course for the takeover or the merger much easier. So there you can argue it's clearly in bad faith, because you can argue that this is the purpose, the main purpose for them. They're trying to keep the fact there is this liability undercover. Yep.
The facts aren't clear on how we didn't disclose the guarantees. Did we not disclose it, as in did we not give access to the auditors to have a look at it? Did we not put it in the annual report? For which year were the liabilities incurred? If they were incurred for the next financial year, then it would make sense to include it in that AGM rather than this year's AGM. Even though the transaction was entered into this year, the agreement was finalized and the contract made this year. So we probably have to look at a lot of technical standards in a sense. When did we do the duty to disclose? To whom did we do the duty to disclose? And how we withheld that disclosure? Did we act in bad faith to keep the information about the loans confidential? How we went about this? Secondly, the guarantees. Investiture wants to bring the action against us as directors of MD&L, right? But it's not clear what the AGM was about. Was it for Metro India Limited, or was the annual general meeting of MD&L?
They're bringing it under for Metro Robotics, because they're shareholders of Metro Robotics.
When I'm saying that AGM that's mentioned here, where we did not disclose the guarantees, was that AGM Metro's AGM, or was it MNDL's AGM? Because if it was Metro's AGM, then investiture would not have any legs to stand on, because they could not bring action against for a breach of a duty that was not owed to them in the first place. So there are a bunch of issues here that we want to look at.
Good. You were going to say something? That's the way I wrote it, but clearly they're asking for further clarification. They're saying, whose AGM was it? So the response here has come out that it is actually a Metro Robotics AGM, is the point that's being made. Good. So it's clear that they're not trying to state what the truth is or argue. They're just giving an interpretation of the facts. That's for their benefit. And you've clearly picked up the two things that they're trying to swing their way. They're just answering it, saying, yes, it's the AGM of robotics, and yes, it's short-term liabilities. So no need for confusion about accounting standards, no need for confusion about which meeting. It's pretty clear, is what they're saying. So now the point is, can you work under 245, therefore? Can you go ahead? Can you bring an action? You can bring an action because remember 245 is supposed to be a class action and it's only supposed to restrain the company from committing an act, or it's a resolution to alter something, or it is to claim damages and demand suitable action against the directors or the auditor. So under 245, it might be possible to bring the action against both the directors for breach of duty, or all three directors for breach of duty, and also the auditors if you want to do so. So what we're talking about is how 245 plays out. What is the aim of 245? So what we have looked at is 245, we have established, yes, it's fine, the member can bring an action. And then we're looking at what the tribunal can decide. So the tribunal, 245 is something that can have a corrective measure. So they can actually say to the company, look, you're not doing things properly, start doing things properly, and give them some sort of corrective provision, pass a resolution, fire that director, appoint another director, appoint a nominee director, so forth. Or they can also bring action against the directors under G. Claim damages or compensation or demand suitable action from or against the company directors for any fraudulent, unlawful or wrongful act or omission, and auditor. So the point being made here is, so under 245, investiture satisfies the good faith test or good faith test. They've clarified those points and they can bring action. And the next point is, how much compensation will they seek? And that's what that's trying to give you some information. Is it says, advise them on their options, and in your advice, consider how it'll impact on share price. So usually if there's litigation, share price is impacted adversely. Right? Unless they win a huge action and the company actually gets money. But usually if the directors are going to be liable, it starts destabilizing the company. Investiture, therefore, has got both loyalties. Firstly, it doesn't want its share price to be hit, but secondly, it wants to change management, which then comes back to Section 145 for you to look at the other orders that they can ask the tribunal for. Question? Question?
I know this is directly related to
Yeah.
how the entity is going to play out. We were going a little back at and looking at how the merger went ahead. And there are a number of ways, but usually how the merger would happen is both voters would speak. Obviously you get representation made by all classes. Classes will have a vote in favor of the merger. So in that situation, it's the argument that they were misled in terms of the financials of Metro Robotics.
Yep. So the merger is between robotics and metronomics.
So Metro Robotics essentially has these guys investiture as their shareholders.
Yep.
And the liability was incurred by Metro India. The guarantees are provided by MNDL.
Yes.
Which is a wholly owned subsidiary.
Yep.
So,
But the merger is between MNDL and MRAL. And the point raised before was that this merger means it's a new entity and the guarantee is still valid and might be called upon and might affect the way in which the liabilities of the future pan out.
no, so in terms of the duties opposed to as directors of the company, the duty for disclosure would not be owed to investiture prior to the merger, right? Now, post-merger...
Why? It would have been good prior to the merger. The merger mightn't have gone ahead.
No, but and it would be owed to the shareholders of MNDL, right, prior to the merger.
Yeah.
Now that's a difference. It's a different matter that the merger might not have gone ahead if it was public knowledge that these guarantees were provided. But at the same time, usually when there's a merger, a lot of times there's a contractual relationship that sort of governs the merger, and then indemnities in terms of if you haven't made disclosures, or if there's certain things that you haven't disclosed, if there are any material provisions that affect how the merger would have happened, if you've sort of hidden some sort of substantial information, then it would be a contractual remedy between MNDL and MRAL.
It could be. It could be.
But in terms of the duties that are owed to the directors, as directors, we would not owe duties to the shareholders of MR, sorry, Metro Robotics, for disclosure to Metro India and Metro MNDL, right? So in terms of action against us, I'm not sure how it would work. Maybe there could be a contractual remedy where these guys could, direct the company to enforce indemnities against Metro MNDL, because we didn't disclose what we were supposed to. But in terms of actual duties of directors, I don't see how we do that.
All right.
Again, on this movement as director of MREL, I'm an investor in a company who, you're asking me to vote on whether a certain merger will happen between me and one company. You don't tell me the liabilities of the other company and allow me to believe that it's a very lucrative deal. Then I sign on it and then I come home and my directors have not really informed me of the realities of the situation. And now I have a problem with that. So you're not going to the other company, but still you're left with the current company who has not really made it clear to us before the messages what their company is.
The point that is being made there is, yeah.
I'm only asking about the interpretation of how, because I always understood this as shareholders of one company, shareholders of the same company, directors of the same company, because of the lack of disclosure that was made prior to the merger.
Okay. So, investiture is directors of MRAL, right? So you're asking, the directors failed to disclose guarantees of short-term liabilities. You're asking which directors are they? You're saying they are the directors of MRAL. Yes, they are. They're saying they're the directors of MNDL, aren't you? Yeah, sure, go ahead. But you're right. The important question here is, how do the three directors in a corporate group operate where they're the same? How do they actually weigh up the interests of each group? Are they supposed to, put on a different hat each time? And corporate groups are common, and there is law about that. What is that D in the top? Oh.
All right. So
Put the shareholding of the other ones. Remember, Metro is a full shareholder of MNDL.
right now it's concerned about investment. So they are shareholders of MRD. Right. So the directors, a loan was taken by Metro that was guaranteed by MND. Now the duty to disclose the loan.
Actually, the point that's being made there is that is not clear. The point that's being made is the loan is being guaranteed by MRAL.
No, it says the guarantees were provided by MND.
Oh, okay. Is that all right? Oh, okay.
Okay, so the loan was taken by Metro. It was guaranteed by MNDL. Now, the directors had a duty of disclosure to Metro and to MNDL. To MRDL, they only owe the duty to act in good faith and to the best of their ability and under 166.
No, so the point that I was making is that investor has a problem because of the merger. So during the merger, when you don't tell us about the liabilities that the other party has, the other company has with us, and and you're asking me to vote on whether the merger should go on or not.
So you're talking post-merger or pre-merger?
So when before the merger goes on, and the shareholders of one company, so I mean, I'm assuming some sort of resolution is taken from the shareholders, right? And investiture is one important shareholder who has to decide on whether the merger should go on. And if I'm not informed about it, I will how am I going to know about it? And if I come out of if I know later that there's not liabilities that is there, that's the problem that I have. I will disclose it. So I'm asking my directors and stuff.
Okay, good question.
So that makes sense. But I could still be acting, so despite the loans that were taken, I could still be acting in good faith and conforming to 166 because I believe that it's a merger that would benefit both the company, shareholders, everybody else, right? So what I get your argument that maybe I should have disclosed it. I should have, but it's not a legal duty that I had to disclose it.
No, but like what she said, it's short-term liabilities, they generally go along with the 6 to 1 year. So it's something that generally has to come about in the annual general meeting.
So what I'm saying is, director had to disclose here, should have disclosed here, but it's not a legal duty to have had disclosed.
So we're only looking, just write the section 245.
Yeah.
Just write section 245, yeah. You were going to say something?
Like, you get what I'm saying? So I had a duty, I had disclosed.
What about post-merger?
I think that maybe the should would also be contestable because in this case it's a huge amount, right? It's a guarantee of 150 million and it was a make it or break it kind of term for the deal. So maybe there was a legal duty to disclose a clause that was so integral and that involved such a huge amount of money and that involved such a huge amount of the company's money once the merger was going through.
Yeah, I mean, what is the merger? I mean, the merger, the new entity working out is we want these guarantees. In which case, all the shareholders will have a reason to be concerned about it. And then it's just, like she said, it's a big amount that should have been disclosed. So whether it should have been or had to have been disclosed is something that I think it will have to, I think it depends on the interpretation.
And what about conflict of interest by a director? It's not like they can ever act in good faith when they're sitting in one. It's a huge thing, a huge guarantee. They're not suddenly forgetting it. Or is it reasonable for them to forget it? It's not something they can forget. And it's a conflict of interest. So the question would be, good faith is the only thing you're looking at under section 166. Could you also argue the conflict provision is breached, and that is also acting contrary to the interests of the shareholders? Because they should actually tell the conflict or disclose the conflict to potential shareholders as well.
Was there a conflict of interest though? I mean, they don't stand to gain anything personally.
They don't stand to gain anything personally from the merger?
Yeah.
Why not? Why do you say that?
No, because they don't hold any shareholders. They don't have any shareholders in any of these companies. I mean, they could possibly be.
We don't know. We don't know if they have. They could have shareholding in Metro. They could get remuneration.
Yeah,
And yes, there is a bonus thing later on.
it's possible, but
Possible.
obviously as directors we have to put forward.
Yeah, no, it's a good point. Good point. So the points that are being made is you might be able to take an action, but you really have to click that to 166. Okay? So all this is telling you is you've got to show it's contrary to the interests of the company. But you can't just work with that. So you've got to go back and say what is contrary to the interests of the company, and you've got to click it to one of the provisions. I agree the good faith one might be hard. I don't even think that's hard, but it just depends. But you have to ask about conflict of interest. And it's not, with conflict of interest, it isn't just your subjective duty. And so you've got to ask the question, will it be an objective duty that the courts will adopt to interpret the section? What a shareholder, what a director in that position should have done, not just what they did, given they might be absent-minded. So you've got to ask that. Okay, so that's one thing. What about after the merger? It's a new entity. These guys are now the directors of a new entity. I just said that, so we've been talking about post-merger. Now we're talking about, we're talking about pre-merger, now we're talking about post-merger. Once the thing is merged, surely they've got a duty to disclose. Even if they didn't before, investiture is their shareholder of the merged entity. They've got to disclose. Shall I leave that with you? Directors, go for it. Give it to us. Slap us down.
No, I don't have anything to add at this point. I would just say that we have a duty to disclose, but the disclosure would be in a manner that is mandated by the Act. So at this point, we haven't come to a point where we were either asked to disclose it in a general meeting, because it doesn't say that we had decided to not disclose it at all. I mean.
Oh, so you're saying the disclosure is coming up?
Yeah, the disclosure is coming up.
So, disclosure can be retrospective as long as the shareholders are agreeable to it, right? Okay, so just to go back a step. So what you're also asking for here, because of this thing that they're worried about the share price, you're asking for what remedy might you want, assuming it's breached. And that's where I wanted to bring your attention to the remedies, which is you mightn't necessarily seek compensation because you don't want the whole world to know. You might just want a better ordering of the company's affairs. So you might actually ask for one of the other orders under 245. Scrolling down is such a pain. Anyway, the other orders include changing the way in which the company is managed. And one of the things that institutional investors often ask for is an appointment of some sort of nominee director. So here it's a declaration, right. It's an order to restrain the company from doing anything that breaches the memorandum or articles, restraining the company and its directors from acting on such resolution, restraining the company from doing anything that is actually contrary to the Act. So you might be saying that under 2451E, 1E, you might be asking for an order to stop the directors doing anything or make them disclose it immediately. And you might also, because it's very wide, because the last one is under H, to seek any other remedy as the tribunal may deem fit. You might be asking the tribunal for a nominee director to watch your interests. And you've got a big enough stake there of 19%. That might mean that you don't give it away. And the other section, of course, is the 447 section, which will catch pre or post. Because you could argue that the directors are actually promoters of this new entity because they're actually debating with each other about how to bring about the merger. So if you say that they're a promoter of the entity, of this new entity, assuming it's a new entity, then you might be able to argue that there's a fraud committed and the directors have committed this fraud and there should be a liability. But as I say, you don't really want the idea of fraud hitting any of your officers because of the impact on share price. So in doing this, we are not taking into account the fines of 25 lakhs that will be imposed for breach of different sections. Anything else on that question? Okay, let's go on to the non-executive director. Pali Hari is especially worried about her position and her vulnerabilities. I forget now what she's done. She is a non-executive director, and oh, that's right. She has a family company, which is Mikey Toys Proprietary Limited. She's the director of Mikey Toys Proprietary Limited, and she has sold that business to Metro Limited. So Mikey Toys, owned by Pali, is sold to Metro Limited. Firstly, is it a related party transaction? Clearly a related party transaction. Okay, because it's a public company and it can be a director of any company, public or private. All right, the second thing is she has sold it. Remember, it's exactly the same as Satyam case. So this is just trying to evoke all those provisions that came in after that. So then the question is, what is a non-executive director? And here you're asking whether she's an independent director, and you're trying to see whether her liabilities as an independent director would also cover this breach. So that is 149, requires an independent director. And they have to give a declaration about their independence. Oh, which section is it? That's right. Appointment of an independent director is in 149. And the duties of the independent director is in the schedule. Is it 4? Schedule 4. Sorry. So Schedule 4 has guidelines, roles, and duties. So the duties include, under Schedule 4, Part 3, it simply lists duties that attending meetings, not obstructing, and so forth. So what you would be doing is saying it's an independent director under Section 149. Schedule 3 applies, but also the general duties in 166 applies, because it applies to all directors. I think there's a little duty here from memory about allocation. Thank you.
Says he must act objectively and he must refrain from any action that will lead to loss of independence.
Thank you. Yeah, it does. So how are you using that?
But I think like she may not be able to act objectively if she is involved in a transaction that includes a company where she has shares. And this will also not make her interest objective or independent.
Okay. One could actually argue there's no doubt about the objective interpretation according to according to Schedule 4 in interpreting 166. Everyone happy with that? So what would be a remedy? Sorry, go on. The point that was made is under Schedule 4, under the duties.
At the same time, it says that director cannot be involved in public interest. Now, we don't
Sorry, what does it say?
that the director should not be involved in a position of conflict of interest and must remove the Senate from such a position. The facts notes state that Ms. Palli participated in any resolution that might have led to this company being purchased. I mean, as long as she removed herself and they did not fall foul of the related party transaction provision, it shouldn't be much of a problem because
That's not mentioned in
but again the
done a lot of position and that we just believe that maybe that wasn't wrong.
Okay, so I think you can include both those things. So firstly, you say yes, it applies, because that point that's being raised wouldn't even come in until the point you make comes in. Because you wouldn't just suddenly say, oh, you know, there's no conflict of interest without quoting the conflict of interest provision. There's no related party without. So you would first most probably say it looks like this could be a related party transaction. So then you say, has the disclosure within related party transaction been taken? Not enough facts to suggest that. If they've been taken and it's an arm's length transaction, approval of the general meeting, then fine. And the board of directors, it's fine. But you don't have enough facts. But still the section comes up. And the second provision you also brought up is again 166 breach. So there again, you remember, like 166 breach only gets you a fine. So if you're advising her, you'll be saying your vulnerability is that you've got the fine, but you also got the shareholders that might be going after you under 245. So you just have to, or 447. So you just have to lay that out for her. Does that make sense? Does that make sense to you? Okay. Any other thing you would raise here? You know, that whole 447 has been introduced to overcome this kind of thing, right? So if it's going to be a big mess, that was introduced to prevent that Satyam thing happening again. So if it's going to be a huge mess and cause lots of loss, then you're going to be able to bring that 447, and you don't care about the company and you think the company is going down anyway, then you'll be using that. The final provision, before we leave that, I don't think I asked about remuneration at all. So can we just go back to this question? And in issue 4, I actually included that section, that point on remuneration, because Krishnan was so interested in section 197, 198. So the remuneration provision. So it says that they have managed to give themselves a bit of a hike because they've discovered this new artificial intelligent robot. So they're giving them a remuneration hike of 2 million each, which makes the package 3.2 million each. And the company's profits have been reduced to 25 million. So it's just getting you to go through section 197, 198 provision and tell us what is the remuneration that can be provided, and if you're going to go over it, what process do you have to follow? Does anyone want to take that up? Okay. So the remuneration is supposed to be not more than 5% for a whole-time director under Section 197. The remuneration payable to any one managing director or whole-time director or manager shall not exceed 5% of the net profits of the company. And if there's more than one such director, the remuneration shall not exceed 10%. So that is talking about executive directors, managing director and whole-time director or manager, not about non-executive directors. So that's the things you've got to pick up here. You've got to pick up the fact that there are non-executive directors, which is 2 people, Bala and Pali, so 2 non-executive directors. And they're being paid more than, they're also being paid a significant amount. So it's breaching that provision under 197. And it basically says if you're going to breach it, you have to go through general meeting approval. So has there been disclosure? And if not, another fine. The final point is to do with Franklin Pension Fund. And this company holds 11% of shares in Metro. And I've tried to just make it like a litigious activist sort of person who doesn't really care. It's a manager, doesn't care about share price falling because they're working for a pension fund. They're just interested in being responsible. So I've just tried to make it a bit of a moral streak coming out. And there are these guys, you know, who mount huge actions. So what can he do in this case, and what fact can he pick up? All right.
Standard action would be to go to the general meeting and raise questions.
But he has 11%.
Yeah, so 11% is significant. Enough to raise questions.
He gets shot then.
Last questions and talk about
Okay, so you're saying that he should raise this as a minority shareholder? 241? Is that what you're saying?
I was just talking about normal
Oh, right.
things where he could ask a question and yell at the directors, I guess.
Oh my God. All right, do you want to take us through that or just tell us, because we didn't cover meetings? All right, so you're saying that what he should do, from what I can gather, is because he's got that percentage, 10%, he can actually, he's got more than 10%, he can actually call for a meeting to be held. Even on the basis of Section 244, I think it is. Yep. Section 244, any member can apply as long as they have 1/10 of the total number of shares. So you're arguing under 244, Franklin has more than 10%, so they can apply under Section 241. They've got standing under 244, they can bring the action under 241, and the 241 is unfairly discriminatory or oppressive conduct. So that's a heading you can pursue. Okay, so what conduct would be oppressive then would be that he's upset about a whole set of events. So he might be upset about the way Metro didn't really act to rein in another company and therefore might have suffered some loss. That might have been not really acting with reasonable skill and care because they actually allowed the liabilities of MNDL to continue, or they covered them. Entering into the contract with Mickey. So they're all the sorts of things you can argue. And also just mixing up the duties and acting in the interests of the group rather than the interests of one company, Metro. So they're actually working out and giving them a huge remuneration hike, because another company in which they have shareholding delivered a profit, and they're getting that as part of their dividends as a company. So they're giving that straight to themselves. So it could also be improper use of profits, breaching Section 197. So it could be that 241, oppressive conduct, is the way, or unfairly discriminatory conduct is the way they could bring the action.
The language is pretty wide. It says that any member of the company who complains that the affairs of the company, and if you read the last line, are being conducted in a manner prejudicial to the interests of the company. I mean, it doesn't even have to be specific oppressive conduct towards these 11%. It can just be that the affairs of the company are being mismanaged in general.
Exactly. So you have to go back to all those boring English cases of Jerem versus Turkish baths and all those cases which talk about how oppression can be interpreted, or unfairly discriminatory, which is a much wider phrase, can be interpreted. Yeah, so that was just trying to get you to apply all the sections and just think about the sorts of things we've learned. Let me just go through and perhaps talk briefly about what this little unit was aiming to do, besides giving me a taste of this wonderful university and having a chance to actually get so excited about all those things that I've been learning. I've just been downloading all these things to read on the plane on Brahmin and non-Brahmin oppressions, which I'm so fascinated about now. But to come back to this is to actually look at one aspect of governance. My area is governance and regulatory theory, and to think about hybrid mechanisms of government moving away from law, not just law, but soft laws and hard laws, and sometimes the transitions in between, and to look at other actors, not just the state. So in this unit, I have not tried to explore the thing you will cover in an ordinary company law course, which is how do you issue shares, what kinds of securities can you issue, how are directors appointed, all the forms they have to fill in, how is a company registered, what fee you have to pay, can you buy a shelf company, how you raise money through the issue of a prospectus. And also I haven't dealt with meetings. I find that the most boring of all, except maybe extraordinary general meetings, kind of interesting. So I haven't dealt with meetings, what kind of notice you have to give, how many days, what kind of resolutions. I've tried to leave all that to a core course and tried to deal with some of the peripheral aspects that I thought would be interesting. So just tried to put this table together to try to illustrate what we have been looking at in this unit over the last few days. So firstly, we looked at hard laws. We've also looked at some hybrid laws, and then we've looked at codes of conduct. And the thing that I suppose that I want to say is that the Act now is clearly moving away from hard law, which was the 1956 Act. The central government is everything. SEBI is asleep. The Ministry of Corporate Affairs sort of does something, but very half-assed. And we're moving away to this idea that they're not going to do it all because it's too hard. So they're trying to actually give more powers to different parties to do things. So that's why I've tried to divide it up like that. We still have the hard law as far as the board is concerned. You'll note Section 149, which is about how a board should function, and you'll note the Section 151. But also, we have the Corporate Governance Code, which is supposed to be adopted. And if you're not following the code, there could be questions asked about whether that is reasonable care and skill. There might be questions asked about why aren't you doing what is objectively accepted practice. Soft law is the UN Global Compact, where companies are going one step up and saying, well, we want to actually adopt laws that are supposedly ensuring human rights, environmental protections, and so forth, and thereby they can become a better corporate citizen, and they love using that in all their literature. So even companies that is, like that Sakhalin company that I was telling you about a couple of days ago, that Russian company is a terrible company, and it's got Putin as one of the key managers, and its manager was a terrible, terrible individual on all accounts, who had caused incredible amount of environmental damage. But they tried to jump on this bandwagon, and then now he's become a spokesman for the UN Global Compact. There was a little bit of cleaning up their act because the funding was pulled because of the Equator Principles and responsible investment principles. But after that, he decided to become a spokesman for those Russian states and decided to become a participant in the Global Compact. So there is a little bit of monitoring that happens, and once you jump in, then more monitoring happens, once you become a party to the Global Compact. Directors' duties, we have looked at all the sections, a lot of which have come in as a response, of course, to Satyam. But we also see that SEBI is getting a bit more active. They're actually issuing those whistleblower provisions. They're trying to mandate it now, and they're trying to give voluntary guidelines on social, environmental, and economic impacts. So in your annual report, one of the hybrid things is you've got to release impact of environment. So if you don't release it in your annual report, you could be breaching it. You could be breaching the Act. And similarly, the National Financial Reporting Authority is taking up all the global standards and shoving them in the Act. So one could say it's making soft laws into hard laws. Majority protections, as I said, we haven't dealt with. That's just Section 88 to 127. That's all the meetings stuff. But minority protections we have dealt with, and we've seen the derivative action and the oppression sections come into play. And this is a response again because minority shareholders aren't protected. And now SEBI has gone in and started issuing these guidelines because it's realizing there are these other players who will do a good job in monitoring what's happening in the company. And it's kind of telling them how to go about it. Liability is still an issue. They're not going to be liable. That's going to be tested. But they might get a small fine, which is not a big deal. And they're licensed. They might revoke the license. So what? But at least they're putting them in the picture. CSR, we've seen that schedule, but we've also seen that it mightn't be that effective. But encouraging disclosure on website is a way of trying to get more people involved to check out what it's doing, and maybe NGOs more involved in maybe becoming a bit more activist and policing these companies. And finally, international companies aren't regulated really. You might have to register here, but so what? And they are still regulated by those global norms. So that's the kind of things that I've tried to go through in the unit. And finally, the usual actors are central government, SEBI, and the courts, but we've tried to see how these other guys can work. Institutional investors are now embraced into the regulatory picture in India. However, proxy firms are just opening up, and they will be, but litigation funders are yet to come. And they will make corporate law a lot more effective. So that's the sort of stuff that I tried to discuss. Any comments or questions? The only final thing is essays, that it's a 2,000 to 2,500 word thing. And I've said that if you wish to submit a draft to me, I'm happy to give you feedback. Some people who are not here today asked if they could submit it 6 or 7 times. And I said, no, only once, because I thought submitting it 6 or 7 times means I'm doing it, right? So you can submit it once, and I can give you some feedback on how to go and how to improve it. And I'm happy to do that. So I'm at Macquarie University part-time. The rest of the time, I'm in the Asian Development Bank. But for now, you can send it to that address because the other one must really block you. That's MQ. Happy to chat and happy to answer any questions. Thank you very much. It's been such a pleasure. And thank you for making my stay so wonderful. See you later. Bye-bye.
you.